Welcome everyone to the State of State Platform Regulation hosted by the Center on Technology Policy at UNC Chapel Hill. I'm Matt Perrault, director of the center. At the Center on Technology Policy, our mission is to craft public policy for a better internet. We aim to do that by engaging with practitioners in the field on pressing topics like online expression, antitrust, child safety, and US-China tensions. Today's panel brings all of that together. We're thrilled to have an opportunity to discuss what's on tap in state platform regulation with some leading practitioners in this area. Our speakers will be able to provide insights on several different components of the tech policy ecosystem, government, industry, and media. The conversation will be moderated by Scott Brennan, who leads our work in online expression policy and state policy. Scott, over to you.
Great, thanks, Matt. So last week, the DOJ filed a new big antitrust case against Alphabet regarding their digital advertising business. Now, this got a ton of press. I'm sure all of y'all saw it. And this was broadly described as this major enforcement action by the DOJ, which it is. But what got somewhat less attention was not only that 8 states also signed on with the DOJ, but also that there's another lawsuit filed almost 3 years ago by a coalition of 14 states led by Texas AG Ken Paxton that covers essentially the same ground as the new DOJ action. Now, while national or international tech regulation often attracts most of our attention, states have really been flexing their muscles in tech policy over the past few years. Now with a divided Congress, making the passage of significant federal legislation unlikely, states are very likely going to be taking the lead in platform regulation over the next few years. So we've put together this incredible panel today to discuss just that, the role that states are likely to play in platform regulation in the coming few years. But also, I hope the panel can give us some sort of sense of what happens behind the scenes, sort of in terms of tech policy making at the state level. So we're really thrilled to have today Senator DeAndrea Salvador, NC State Senator and co-sponsor of the Consumer Privacy Act, which was introduced last term, Assemblymember Buffy Wicks from the California State Assembly and co-sponsor of the Age Appropriate Design Act, Ashley Gold, technology and policy reporter at Axios, and Will Castleberry, managing partner at Foundry 10 and former vice president for state policy and community engagement at Facebook. So welcome all again. We really are so thrilled to have you all. I'll say I will reserve some time at the end, 10-ish minutes, depending on how things go, for an audience Q&A using the Zoom Q&A feature. However, if you all have questions as we go ahead and submit them. I will try to keep an eye on the Q&A list and might try to sort of integrate questions from the audience as we go, but no promises on that. All right, so I want us to start with one of the most active areas in state platform regulation, privacy. Senator Salvador, last term you co-sponsored what would have been a major overhaul of consumer data protection in the state of North Carolina, the North Carolina Consumer Privacy Act. So maybe you could briefly tell us a bit about the bill. What are some of the central provisions, and what's the future that you see for it in the coming term?
Yeah, and I'm certainly happy to share, but I gotta say, being on the same call with folks from California, which have really been game changer for our state, really the West Coast between California and Washington State, their provisions really got us on that track. So I'm happy to share, but I'm gonna say I think the historical knowledge, we certainly are in for a treat as we hear from Representative Wicks. But really, when I came into my first term in the state Senate, one of the key kind of elements I felt like I really thought was important to introduce was around, consumer privacy and data protections. It's just something for me personally, I have become more informed on, both from learning about, algorithmic biases, but also just looking at misuse of personal information in some instances, whether that be our heightened awareness after Cambridge Analytica. So when I introduced that piece of legislation, it actually was more looking at like, the Overton window of like, how do you push what is, reasonably understood or maybe accepted and start that conversation. I quite honestly knew that this would likely be more messaging and to essentially spur engagement and curiosity among members on a topic that I don't think historically has been addressed so comprehensively. So it did include a number of provisions similar to what you might have seen in the first installment of California CCPA. So looking at ways to essentially give consumers the right to access, delete, really just be more informed and empowered stewards of their own personal information, as well as looking at that version. It did include a private right of action as well. So again, it was more for me, just knowing that this was kind of something, both me as just a person in the state, but also me as an elected official, I thought was just sending the right message for the people who elected me and sent me to serve. And, filing that, I was pleasantly surprised that there were many folks who reached out in support of the bill, even in districts that were, 4 hours away from my own, just to say that they really appreciated that and they just wanted to be a part of that work and see what we can do to help. And I think, 2 years later, we're in a much different place as it pertains to what states are doing on privacy. I'm really excited about where we are now. But yeah, that original bill was really I just wanted to set the stage, start the dialogue around some of these key provisions and just spur conversation.
Great, yeah, and I don't want to put you on the spot, so don't feel like you need to share anything that you don't want to, but you kind of hinted that there might be some revisions that you're thinking about for the coming term. If there's anything you can share about those.
Yeah, I am planning to definitely introduce something new. And, it is my hope that we can have this be a bipartisan piece of legislation for our state. So I'm starting key conversations with folks to understand what any, potential reservations or heartburn would be. But I think as we look now, we have essentially the core 5 who have passed laws across the U.S., starting with California, but we have our close by neighbor of Virginia, ranging all the way into like the middle with Utah, et cetera. And so we have a number of states and examples that, do share some commonalities, but also just show the political possibility of it being able to get done. North Carolina is somewhat of a split state where we have a Democratic governor, but, Republicanly controlled legislature. So I think having states like Utah, et cetera, who have shown these models in maybe a different degree can be implemented in a more, amongst a more conservative caucus, I think certainly helps to drive interest in a new way. So yes, definitely working on it. Actually just wrapped up some meetings pertaining to it. North Carolina is really fortunate that we, the Department of Information Technology hired a chief privacy officer last year. And she just has a wealth of experience. So we're going to really try to lean on some of the knowledge of folks in the state to see what a North Carolina version of that bill might be.
Great, thanks for that. Yeah, I do want to go back to something you brought up a minute ago, how the original version of the bill included this private right of action.
Right.
I think this really kind of seemed to distinguish the bill as compared to many of the other kind of comprehensive privacy bills that have been introduced or passed, other than the California bill, which also included a private right of action. So I'd love to sort of hear more about sort of your thinking of including a private right of action. If you could give us a bit more background on
yeah, I mean, I had seen in some other instances where people were considering that. I knew that because it was more of a messaging and more to push, I thought it was be an interesting approach to push maybe at the further end, whether or not that was a political reality. So it does give a little bit more flexibility kind of as I was approaching the bill and looking at where my focus in terms of movement would be in the upcoming legislative session. I think it just allowed more flexibility with just, again, spurring the conversation and getting notice and attention. I think there are certainly pros and cons to private right of action, but I'll be very frank, there are a lot of advocates that are very strongly against it. I think that's why we see I think California does have a private right of action, but then all the others do not, if I'm correct, and correct me if I'm wrong there. But I think that most likely is you see many states making that progress is because they decided to concede ground. I think even as we look at the conversation federally, when they were looking at the ADPPA, that was, the private right of action, what window would they start to enforce that? I honestly think in a state like ours that, private right of action conversation may be better federally if they ever do make some momentum. But, it just was, I thought it was an interesting starting point, again, for the conversation and to really allow people to express what concerns, reservations they might have, or why they thought it was beneficial. So I just kind of thought I would put it in there, kind of knowing the purpose of the bill.
Yeah, no, that makes sense. And so I want to bring Will and Ashley in to at this point. And actually, I want to pick up on something you said about sort of your hope for maybe a more bipartisan sort of approach moving forward. I think one of the things that's always kind of interested me looking at the past few years in the comprehensive privacy bills that have been passed, that we see both Democrats, like in California, in Connecticut, and Colorado, and Virginia, supporting and passing these bills, but we also see Republicans in a handful of states introducing, and then in Utah actually successfully passing them. So there's clearly interest in both parties at like significant privacy reform at the state level, but where are those actual points of overlap that we could see compromise? So actually, I'll just open up to anyone who wants to kind of jump in here, who can share some sort of insight for us.
I would just say on the federal level, as far as the private right of action goes, that's been one of the main things that is tripping up a federal privacy bill. And at least on the federal level, I know this doesn't exactly line up with what goes on in the states. It's generally the Republicans that are opposed to a private right of action and the Democrats that are okay with it. Preemption of state laws and private right of action have been the sticking points for federal privacy for like years now. And occasionally sort of like the bedfellows on who's for what provision and who isn't change, but overall those are like the main sticking points that is keeping a federal privacy bill. So it's obviously interesting to see what the states do. Private right of action generally, like my instinct when I see that is that a tech company is never going to be okay with that. That's sort of the sign that you're not going to get them to sign on. Maybe that's changing with the proliferation of state laws, but that's kind of how it's been historically.
Yeah, and I mean, at the state level, I do think this really isn't a very partisan issue. Senator Salvador is absolutely right. The things that these bills do make a lot of sense in terms of people's ability to govern their own information. The private right of action does exist in the California law, but it exists in a very narrow state. It exists with regard to the breach of security, which there are very valid arguments for why that makes sense. If a company does something bad and they know that they do something bad, then it makes sense to have a private right of action and statutory damages. I think where industry tends to push back a little on the private right of action is when it's like a general private right of action for the enforcement for the entire measure or legislation. And one of the reasons is these are very elastic laws. I think the Virginia bill says reasonably like 27 times or something. And so if that were to be enforced by a private right of action, it would just lead to a ton of litigation from the plaintiff's bar who would just say, that wasn't a reasonable time, I'm suing you. That wasn't a reasonable security measure, I'm suing you. I think from the industry's perspective, Josh Stein is a very smart lawyer and he has a very good team. If there is confusion about whether or not something is reasonable or not reasonable, for him to have the ability to sit down and quickly get a team together to make that determination, to us, makes sense for businesses and makes sense for consumers. I should have started with this, but I am representing my own opinion here, not that of my clients, former employers, or any particularly family members. This is just kind of what I think.
Yeah, of course. Well, thanks. That actually raises a really kind of like big and difficult, perhaps even unfair kind of question to ask here, which is, when something doesn't pass, policymakers often say it's because of like tech lobbying. So how much does tech lobbying actually really influence the outcome of a piece of legislation? And I'll just open this up to anyone who wants to answer this question.
I'm happy to dive in here. The tech lobby has a very robust lobbying effort in the California legislature. And we've got an interesting history here. We passed CCPA, I think it was in 2018, I want to say. That was heavily negotiated. And then we went to the ballot in 2020 to establish a privacy agency to help do a lot of the enforcement and guidelines and stuff. So I think we're one of the few states that actually has a privacy agency within state government. I sit on the privacy committee in the legislature. We also have a privacy committee in the assembly, which I don't know if a lot of state legislatures have that as well. It's privacy and consumer affairs. Which to me is one of the most fascinating committees. It is, obviously it's bipartisan committee, as they all are. It's comprised of a lot of parents. And I'll tell you, it's one of the only places where I think we have truly bipartisan conversations, where they're almost nonpartisan conversations, where it's just about how do we, at least in the context of my age appropriate design bill, how do we create better safety standards for our kids online? And so I'm going to weave together a little bit of some of the previous comments that have been mentioned. My key joint author on my age appropriate design bill was a guy named Jordan Cunningham, who's a Republican, who's a dad of 4 kids. And he and I just worked very closely together on this and other tech regulation bills. And, he was the one he had a similar bill that was, or a sort of companion bill that was pushing for allowing for private rights of action for social media companies to be held liable for addictive behavior and some of the real adverse effects we saw coming out of the whistleblowers' findings, right? And he was the one who was full-throttedly pushing for a PRA, which ended up getting taken out of the bill, and it got held up in appropriations in the Senate. But he's a Republican who was out there forcefully on this issue. Now, I also know that some of the Republicans in his party are like, what are you doing? And Jordan's just a strong leader in the space. But I do think when it comes to this space, in politics, this is one of the few areas where I genuinely think Democrats and Republicans can come together to actually solve some of these problems. But to answer the question you asked, the tech lobbies, especially in California, obviously this is home of the tech industry. We have Facebook, Google, all the major tech companies are based here. They have developed a lot of sophistication around this here, and they hire a lot of lobbyists. Now I have an open door policy. I always sit down and talk to the opposition. I had a lot of conversations with Meta and, name the company when I was navigating my bill. And frankly, those conversations for me are enlightening. I'm a politician, these are people who run big tech companies. Like, they have a level of expertise in the space that I do not have. Now, I don't always agree, right? Or I want to shift and ensure that what I want to be as the sort of priority, i.e. safety for kids online, is issues number 1, 2, and 3 in their C-suite meetings on a Monday morning, as opposed to issue number 45, 46, and 47. And so that's what I view my job as a lawmaker to do, is to make sure that those conversations are forthright. But they do have a lot of lobbyists here in Sacramento. They're very well established. But again, you got to work with all sides to come up with good policy.
Yeah, I think that makes a lot of sense. Absolutely. I also kind of want to gently push back on the misnomer that there hasn't been a lot of tech policy or law passed. I think that's certainly the case at the federal government, but I think you could argue that there hasn't really been any law of any kind passed at the federal government for the past 20 years. But if you look at tech starting in California, usually in 2003, we have breach of security bills that passed there that are now in place in 50 states. We have anti-spyware bills. We have bills that govern what you do with decedent account information, something that was kind of very hard nut to crack, that the industry, the Uniform Law Commission, and policymakers sat down and said, this is how we're going to address it. Non-consensual intimate images, horrible practice. I think the tech community helped make California's law stronger. Kind of the initial version had an exemption for if a person took the picture of themselves, and we said that's not our findings. We find that a lot of times there are selfies that are used to blackmail people. So there's a pretty healthy canon of tech law in the states right now. It usually starts in California and then spreads. And I think it's created a pretty healthy environment. And my guess is that the privacy is just kind of the next step in that. And we're going to see the same thing with the privacy laws in the next few years that we saw with breach of security and spyware in past years, where a few states will pass it and they'll kind of create these buffers, with kind of California being here and maybe Utah being the less stringent. And then 7 laws will pass this year, and in 2 or 3 years, we'll probably 45 to 47 state privacy laws.
Do you think that we'll have 45 different sort of privacy laws? I mean, that seems like the nightmare scenario that people are always sort of wringing their hands over, right? The horrible patchwork. I mean, actually, this is something I really wanted to talk about anyway, which is, what are we seeing sort of in terms of the development of different models of comprehensive privacy reform at the states? Like, does it look like it's sort of coalescing around a particular bill that is just going to be passed in 50 states?
I think we have the guardrails. I think we have Utah and California. Historically, the way it has worked is that state legislators will work kind of within those guardrails for 2 reasons. One, if a bill is already passed in a state and companies are complying with it, they're not going to get a lot of pushback for the companies that are already complying with the California bill. So there's really no need to go to Nevada and say, oh, this can't happen here. It's also a bit disingenuous. The second issue is it's a known quantity, and folks know it works. And the third issue is, if another state law goes too far afield, then you actually do start having Commerce Clause issues. So, right, North Dakota can't say you must do this, and South Dakota say you can't do this. Like, when you get into those situations, then there are, I think, real constitutional concerns about the state laws. And in all the laws from, revenge porn to spyware now, the states have been very disciplined and responsible in keeping them consistent enough that that's never been an issue.
I would just add that maybe a couple years ago, at least in the federal privacy debate, there was this fear that it would end up being a patchwork, and that's why there was so much urgency to get a federal privacy bill passed. But it feels like we're past that now, and we're just going to have a patchwork, and that's just what it is. And I feel like there's a little more acceptance to what states are doing because the cat's out of the bag and they're just moving along. So I don't really see a federal bill coming, like swooping in and preempting all these laws and saving the companies from the patchwork. Like, my observation is we're past that point.
The federal government's been trying to pass a breach bill since 2002. I mean,
There you go.
Yeah. Cool. Well, I do want us to touch on some of these other like big areas in platform regulation. So I think the next one that I think we should address is child safety. Which of course also, right, like has a great deal to do with privacy as well. So Assemblymember Wicks, obviously you recently co-sponsored the Age Appropriate Design Act, which was one of the biggest pieces of state platform regulation that passed last term or in several years. So maybe you could just kind of share a bit briefly about what are some of the major provisions, but also like what are the provisions that you think are going to have the sort of biggest impact when the law is actually goes into effect next year.
Yeah, so I don't know if you saw recently the U.S. Surgeon General called for safety standards for kids online. And I kind of view this bill as exactly that. It's trying to create safety standards for kids online. And I think, I'm a mom of 2 little girls. I've got a 6-year-old and a 2-year-old. And my hope is that, in 5 years, when they're like really confronted with the onslaught of being on the internet in a more robust way, that we have created some guardrails for our kids online, because we're seeing a lot of obvious negative impacts as well as positive. I'm not a Luddite, my kids are digital natives. They will be, they're going to operate in the modern world, but I also want them to be safe. I want all of our kids to be safe. And obviously we're seeing more information around, the amount of time kids are spending online and spending on social media and the impacts for them, especially as they're, in their, middle school years and their teenage years. And none of us liked middle school, let's be real, right? And then navigating it with social media is just like, it's such a difficult emotional challenge for kids. But essentially, I'd worked for Common Sense Media before I became elected. And so I've worked in the space. I'd done some bills prior to this, really looking at this space, looking at things like, the sort of addictive behavior that is perpetuated when you're, on YouTube and you're going from like one video to the next, to the next, to the next. It's hard when you're 6 years old to put the tablet down. Now, I understand there's parental responsibility, and I have this fight with my child all the time. But also, let's make it easy. Let's make it more of a fair fight, right? Give the parents really like some more equality here in the fight. But I had been approached by Baroness Biban Kidron, who started Five Rights organization in the UK, and she wrote the UK version of the age-appropriate design law that has been in effect now for a couple of years in the UK. And really, the whole premise of it is, how do we ensure that our online products that are accessed by children are created by design and by default for kids? And so that was the premise of the bill. And so what we did in California is we've basically, we wrote a bill that requires our privacy agency to do just that. And so there's some very specific things that came out of the UK bill that I think we'll see similarly here in California. So for example, making Safe Search the default search engine on Google for anyone under the age of 18. Turning off push notifications after a certain period of time, depending on your age, because we're seeing kids now are sleeping with their phones in their rooms. And the push notifications we know are keeping them up until 10, 11, 12 o'clock at night. So if we turn those off after a certain time, after, 9 o'clock, 8 o'clock at night, the kids are less likely to be sitting there checking their phone all night long. Not allowing for direct messages of adults who are not in your network. So there's very tangible things that honestly are pretty simple, that our company should be doing. And again, I met with a lot of the tech industry on this, and a lot of them are parents too, and they don't want their kids to be in a vulnerable situation, but it's ensuring that the things that we are confronting here are moved up in terms of the priority for the companies, that they have to do it. And so my hope is that if we create a floor here in California that matches the UK version, that this is the standard by which the companies will do. So that if you're a kid in Nevada across the border, you're going to have the same protections as the kids in California. We did a pretty long runway of implementation to make sure we're doing it the right way. Within the bill, there's a task force that's created to help think through all the various guidelines. We wanted the agency to do the guidelines. We don't want the legislature to do it because technology evolves so quickly. And if we had to legislate every time there was a new platform or a new thing, our process, democracy is not known for its speed, which is good, but, and legislators aren't sometimes the most tech savvy people. So really empowering the privacy agency to kind of think through the bells and whistles on this is important. And then we also put in a right to cure language, and that was a request from the tech industry. And the reason we did that is the goal is not to be punitive to the tech industry. As someone who represents a lot of the tech industry, that's not the goal. The goal is to get them to comply to the law and to create a better, safe place for kids. So those were some of the negotiations that we went through. There's a lot of privacy protections within it. And the whole goal is, again, it's kind of what the Surgeon General called for is safety standards for our kids that are online, because we know that we need them. I think there's going to be more iterations of this too in the legislature this year and beyond. This isn't going to solve all problems, but I do think it's a step in the right direction. And we have seen other states who are interested in putting forth this legislation, and we've been reached out to by members of Congress as well on potential federal legislation. And again, this was very bipartisan. We have 80 members in the Assembly, 76 voted for it. Yeah. So for all those red states or purple states, blue California passed it, but I think other Republican and right-leaning states could pass something similarly as well.
Yeah, I do want to follow up on what you just said about, we're beginning to see similar legislation introduced in other states. How closely are you working with legislators in those other states? Like, what do you think, coming in the next year?
Yeah, New Jersey, New York, Connecticut have all reached out. We've had some conversations with them. It's varying degrees. And I learned a lot from the UK because we had the tech companies on the record on the things that they liked and didn't like. And so for me as a lawmaker, it was much easier if I could say, oh, Google, you already said this, or Facebook, you already said this. Like, why would this be different here, right? So it made it easier because it had already been navigated in another context. Now, obviously, regulation in Europe is different. And so we had to adjust for our nuances here. But everyone likes to say in California, as California goes, so goes the nation, which is sometimes true. But it's certainly like an ego thing for the Californians. Governor says it all the time. But I like to actually model other states that have done it or other countries, because then you can see where the tripwires are, where the challenges are, where this has already been discussed and litigated, where it's already been thought through. So we had the benefit of that in the UK, but I do think we're going to see other models here in the US and in states. But those are the three states that come to mind.
Right. Anyone else want to add on to that about other states, like what we're expecting to see in terms of child safety legislation in the coming term?
Well, this is a remarkably busy year for child safety, and the Assemblymember's bill is certainly on the more reasonable side of some of the regulations. I know that Texas and South Carolina have introduced bills that would prohibit anyone under the age of 18 from having any sort of social media account at all. Other states have strict parental notification and verification before a 17-year-old has an email or an IM account. I think the Assemblymember was exactly right. This is something that the tech industry had worked with in Europe, so it was a known quantity, and the requirements seem very reasonable, and most of the responsible platforms were doing a lot of that already, particularly the no notifications, making sure that adults outside of a minors network couldn't IM them and things like that.
Yeah. So we did just get a question from the audience. Someone was asking about the lawsuits against the Age Appropriate Design Act brought by NetChoice, as it says here, as a violation of the First Amendment. And I think, I don't know if anyone wants to speak to that, but I think more generally, like, it would be, I'd love to hear kind of thoughts on some of the concerns about provisions in the bill. Assemblymember Wicks, you did say that said that the bill did pass with pretty significant bipartisan support, but there has been some concern around particular provisions. So yeah, I'd just love to hear your sort of thoughts on that.
Sure. Yeah, I mean, I feel pretty confident in how we crafted the bill that doesn't violate any First Amendment or Section 230 landmines at all. This is about making sure that our products are safe. Turning off push notifications, that's common sense. Making safe search the default, that's common sense. Things like this are, I think, common sense things to keep our kids safe. And I'm pretty confident the bill is going to be, the law will be fine and as it makes its way through the court process. So we were very mindful of that. Ledge Counsel was very involved. We had a lot of our legal team involved, and it's a challenge when you're in the States because of Section 230. How do you create reforms while not getting preempted by that, right? And so I've run my head against the wall on this many times in other bills I've looked at or ideas that we've had, and this one we feel very confident that we're going to be fine.
Anyone else want to jump in on that? Senator Salvador, not to put you on the spot, but so the privacy bill that you introduced last year also has significant provisions related to protecting children's privacy online, especially around things like controllers' ability to process sensitive data. I'd love to sort of hear more about your thinking on those aspects of the bill, but also any sort of interest you have about additional efforts to protect children's safety online.
Yeah, I mean, like the representative, I too have two small children. So, and also, are talking to many parents who do have that concern, and I share it. Kind of similar to how I approached the original bill, and kind of going back to that Overton window, I thought it was just kind of putting things out there, because I just found like some of the conversations might have been had in silos or not really progressing. I do think if it is something that will be approached this year, it may be separate, a separate bill of some amount. I have similarly looked at, what they're doing in the UK. And I just kind of, like you mentioned, need to see what that context might look like in a state like North Carolina, because certainly the hope is, once you kind of start the conversation and have the interest, then determine where we can go from here. And I think particularly pertaining to any social media, there has been growing bipartisan conversation about the use of social media, both from like a security and data protection lens, but also privacy. Our governor recently did his order taking TikTok off of all state devices, and essentially prohibiting that. And that was really spearheaded by both Democrats as well as Republicans. So I think there is growing conversation to be had, the definite meat of which I think is still going to need a number of stakeholders to come together and see what that will look like in more detail. And we're just kind of getting kicked off in session. Things are still moving a little slow. I don't even think we'll have votes this week, if I'm being honest. So I think that there's a little bit of time before we get to that, bill filing deadline in early April for things to come, to light a little bit more, and the appropriate folks to chime in on that. But I do think it's incredibly important. I think as we see devices utilized not only for recreation, but also for day-to-day schools, I think we have to think about the way we can protect children while they can still learn, grow, and utilize the many benefits of technology, while not accidentally, stumbling into something from just being young and maybe just not having the digital literacy just yet, that we could have prevented through law. So I think it's certainly an intention. In terms of the approach, I think we'll see. I need to have some key conversations. Certainly would appreciate talking to the Assemblywoman about her learnings and experience, and kind of maybe what some of those initial sticking points were. But yeah, that's kind of where I'm at with it.
I would love to.
Thank you.
Right. Yeah, I feel like I can't in good conscience just like let your pass and not address pick up on TikTok, like your reference to TikTok, right, which just seems to be like one of the biggest stories out there, certainly at the national level, with the new bill that would ban TikTok, for the country. But we're also seeing, right, as you mentioned, I think we have, I don't know, maybe more than a dozen, 20 different states that have now banned TikTok on government-owned devices. I guess I'll just put this out to anyone. What's next for states and TikTok? Is there anything else besides banning on government devices that we expect to see? What do y'all think is coming?
I'll say I haven't heard of specific legislation just yet. It does not mean that it won't come. Sometimes whatever a member gets inspired by. I saw most of the comments essentially commending that. I think there was also questions about with state-owned devices, like what is the usefulness of it? Like how was it even being utilized for that as well? So just generally, I think folks thought that was a sufficient first step. And some might have disagreed with the governor's approach on that, but overall, I think folks were not necessarily vocalizing that. I've heard directly any potential additional things. I think the conversation did start more in the House, so I will be really clear there in terms of the initial interest and engagement. But yeah, we'll kind of see where we go.
I'm not familiar yet with any bans on TikTok in California, but it who knows? We're a large state. We got a lot of personalities in the legislature, so we'll see.
I was just going to ask for Senator Salvador. I mean, do you think the prevailing sense among state lawmakers is that TikTok is dangerous because our data might be being exposed to China, and therefore having it on a state device is like a cybersecurity vulnerability? Or is it that TikTok is dangerous for children, but we can't ban it outright yet, but we can start at the state level? Or is it both?
I think both can exist. And if you look at the governor's statements, is really around security of information. I think that was the overarching theme for state information potentially being accessible. I think both in his order as well as media interviews, that's essentially what he was stating. And I think the members that worked with him to produce that, they also were looking at it from a more of a security of state information lens. I don't think that prohibits that other members may take those conversations further in terms of looking at the impact of not just TikTok, but maybe other social media companies or just digital companies on children. But the focus was pretty kind of lasered in on government information.
It's a pretty remarkable step from one to the other. Banning it on state devices is pretty easy. You don't need a law or a kind of a governor's executive order. You just need the IT people in your state agency to say you can't use these devices. I worked for the state of Maryland, and it was the last century, but they gave you your computer and said only do state work on your computer, don't download anything else. So I completely agree with you, Senator, that is strictly a security question. To move from there to I am banning a specific product from all consumers in my state from using it, I don't know how you would get there. That just seems like a really, really hard thing to do.
Yeah, for sure. Anyone else? Okay, great. So I want to be conscious of time and make sure that we leave some time for Q&A, but I also feel like we have to at least touch on the Florida and Texas bills that were passed back ages ago in 2021. These two bills, impose pretty significant restrictions on how platforms can moderate content. They're of course sort of on hold pending Supreme Court review. And there's a lot to say about these bills and a lot to ask, but Will, I actually have a kind of target specific question for you. I'd love to get your sense of what you expect to sort of see regarding these efforts to limit platform moderation in light of the kind of continued legal challenges to these bills. And I can sort of imagine like two options, right? Like on one side, we could see, well, the other Republican states could see the success that Florida and Texas have had in passing these bills, and some success with the courts, and so they could be, rolling out more of these sorts of laws. On the other side, we could see them figuring, well, there's really no reason to do this until the courts have kind of had a chance to fully review. I don't know. What do you think? Like,
we've seen a lot more introduced. So we've already seen Republican states introducing these. The bills come in kind of two flavors: the Republican version and the Democratic version. And the Republican version is you can't take anything down, and the Democratic version is you must take things down. So we talk about dormant Commerce Clause, issues that becomes a challenge. It's going to depend on what the Supreme Court does, and no one could predict the current court. It seems to me unfathomable that the courts would say that a private entity was compelled to keep speech up that they didn't want to keep up. I don't see how that would work. I don't see how then you wouldn't have to allow nudity and hate speech and spam and child predation, all sorts of terrible things on networks. I think companies need to continue to try and do a better job to protect their customers from that type of content. And so I can't imagine a scenario where the court would say this private company no longer has the right to moderate what happens in their platform. It would be like telling a restaurant you no longer have the right to require someone to wear a dinner jacket because you're offending the First Amendment right, of the patron. Said that, Supreme Court's the Supreme Court. They don't ask me my opinion on these things. If the Supreme Court were to uphold Texas and Florida, then we would see a flood of very similar bills. What the internet would look like after that, I candidly don't know.
Great. So you mentioned, that we're seeing, right, we have both Republican bills like we've seen in Florida and Texas, but also these Democrat bills. So I'd love to sort of get everyone's sort of take on what the left is doing in this realm of content moderation. So, we have seen, I think we see a little less sort of attention being given to Democrat sort of interest in this area. Certainly, we've seen some success in California with the new transparency bill, in New York after the Buffalo shooting with it was transparency and mandatory and hate speech reporting. But I guess Assemblymember Wicks and Senator Salvador, I'd love to get kind of your sense on what are the Democrats interested in here? Really, what are they pursuing? What are y'all pursuing? Like what are we likely to see kind of moving forward here?
Yeah, I mean, I think, I co-authored a bill last year around transparency that Jesse Gabriel, the chair of our privacy committee, did. And so I think we're trying to figure out ways that we can be a part of the conversation while not in violation of Section 230, right? And I think we need Section 230 reform broadly. It is difficult to engage in any kind of content moderation because of Section 230, though obviously hate speech and things like this, death threats, all of that stuff is fair game, and ensuring that content moderation can exist in that context. But this is always the challenge, I think, for state lawmakers to really push the envelope on that because of Section 230, which remains a challenge, which is why we need reforms federally. But, we'll see what happens federally.
Yeah, I completely agree. In terms of here in North Carolina, I haven't heard, and I've been kind of involved with the legislative agenda planning for North Carolina Democrats, and I don't think there's just a stance yet. But nationally, I think what we heard from the representative in terms of transparency reporting certainly has been something there, as well as disclosure as it pertains to algorithms. I think I'm trying to recall which state. It may have been Minnesota, or there's a couple states that were looking at, some of those measures. So I think we will certainly see some of these things kind of coming up. But as she mentioned, there are some limitations in what could possibly be done. So I don't know just yet, as far as North Carolina, if that would be something any member is planning to tackle. And I think it certainly could vary on where they fall on the political spectrum too. Just what we'll see, I think Will had a good summary of how things are falling in some of those categories.
It seems that the Democratic versions modeled the old CalAPA model pretty closely, where it is really just the consumer has a right to disclosure of what's going to happen on the network that they go to. So in the same way that there's an obligation to have a privacy policy, so a consumer who wants to go on a platform can see how their data is managed and maintained. The consumer should have a similar right to understand what type of content will or won't be on the platform. And that puts the companies in a bit of an interesting situation, because if they make claims and then don't abide by them, they've arguably committed a deceptive trade practice and are subject to the UDAP statutes of the particular states. So while it's not, I don't think, kind of a direct legislation, regulation of speech, and would not fall to Section 230. It does create this obligation to be transparent and clear with the parents and people. What are they going to expect on this network? And then in making those obligations, they are bound by them through the state's consumer protection codes.
Okay, so we only have 10 minutes left, and as promised, like I want to open this up to the audience. So please, anyone out there, like if you have questions, send them in through the chat. We have a couple questions already. So for the first one, I'm guessing this is for Assemblymember Wicks. What is William Reinhardt asked, what is the timeline for the Children's Data Protection Working Group to produce the report, and how might we get involved?
Sure. Thanks for asking. We would love your involvement. It's due on or before January 1st, 2024, and it's going to be due every 2 years thereafter until 2030. And it will include input from lots of stakeholders, advocacy organizations, academia, consumer protection advocates, businesses, and others. And you should feel free to reach out to my office. You can just Google my office and we can get you engaged and plugged in.
Someone else asks, how do you properly strike a balance between wanting to protect children while simultaneously respecting online anonymity? I think goes on to talk about the balance between requiring, this person's talking about child safety bills, requiring kind of more invasive methods of age verification while protecting user privacy as well. So it's sort of yeah.
This came up a lot. There was towards the end of the bill process, there was some sort of fear mongering going around saying that essentially age appropriate design would shut down the internet completely. No one in California would be able to access the internet unless they submitted their driver's licenses verification for every website they went to. That is not true. The internet still works in the UK. But there was some blocking and tackling there that we needed to do on getting the facts out about what the bill does. But essentially, it requires the companies estimate the age of their users with a reasonable level of certainty appropriate to the risk. So if you're an online dating website, you're going to have a stricter need to prove that you're over 18 because you don't want 14-year-olds on a dating app, for instance. But if you're the Sacramento Bee, the risk is not as high if you have a 16-year-old on the Sacramento Bee, right? And I can assure you that Google knows the age of their users. And these companies are sophisticated. They understand the age with pretty certainty, pretty good accuracy. Of who are using their platforms. Facebook, I mean, there's whole data analytics teams that are devoted to literally exactly this because their advertising dollars sort of depend on it. So we know that there are ways that you can do age estimation. This is what's going to be in the guidelines that are going to be put forth by our regulatory agency to make sure that this is a reasonable estimation of how old the users are. They've done it in the UK pretty well. The internet did not collapse in the UK. People are still using the internet, and we feel pretty confident that we can sort of strike the right balance. But again, this is also why I think it's important that we empower our regulatory agency comprised of experts to help figure out these things with a robust stakeholder process so that it's not politician making up these things, putting it in legislative code.
Someone else asks, do we expect to see any sort of state legislation on right to replace bills? Anyone? Any thoughts? Okay, great question. We'll see. John Perino asks, again, for Assemblymember Wicks, are there a few specific common sense actions you'd expect online platforms would need to implement to comply with the California Age Appropriate Design Code Act? Can you expand on the safety by design proactive measures you briefly mentioned?
Yeah, and I think the best way to do is to look at what they're doing in the UK already. They've already gone through this process. I mentioned the push notifications. That's a simple one. The direct messaging by folks that you don't know. What kids are advertised to in the App Store is also important because there's a lot of apps that are really for adults only. They're advertised to kids in the App Store. YouTube has turned off autoplay for kids under the age of 18 because the autoplay is a pretty addictive mechanism. I mean, we're all victim of that, aren't we? Right. So there's, I think, things like that again are very tangible and I think concrete ways that we can keep our kids safe online. And so there's a number of different things that have come out of the UK that I think provide a good roadmap to, I think, what we should expect to see here in California as the bill gets implemented.
Great. I have another big, slightly unfair question. So throughout this conversation, we've been talking about the question of federal preemption has come up, whether that's kind of in the very kind of direct, pragmatic sense of this is the concern that has really held up federal privacy legislation. But I think there's a sort of like bigger sense in talking about state policy. And so I'd love to get y'all's sense of what role should states play in tech policy, regulating on issues that almost always have sort of national or even international import. Any thoughts on that?
I have thoughts, but I've already spoken a lot. I'm happy to let other folks take it away.
Now, I was going to say, I'd be curious to hear your thoughts because you have something in place. I think depending on where people are at that mature, like how mature their state is in terms of where in the number and scope of privacy, it certainly is askew. For some of the business owners in our state, I, recently talked to some and they were kind of like, well, that actually federal would be a little easier for us. It's, just something to comply with. I think for others who particularly maybe on the more consumer side, I could imagine where if it's preempting and much lower, they might feel, as particularly with something like a ballot initiative where, your folks are voting on those matters. I can imagine the sentiments may be different because they might feel like something's being taken away. So I think, without having it in place, our direct relationship to it, at least maybe in states like mine, may be a little different from folks who do have, laws that they put time into and work with their stakeholders and their constituents to build. So yeah, I would certainly just value kind of hearing that perspective from you.
I mean, I think, in California, as I mentioned, like the work that I did last year was really building on years prior, right? And again, I think part of it's because we are home of the tech industry. We've been living in we've sort of tech literacy, if you will, amongst lawmakers and policymakers and others. We also have people like, the first partner, the governor's wife, who is a strong leader on children's safety online and protecting kids and has done documentaries on it. And so there's just, I think, a rich culture and history and policy expertise in the space here. But I view my job as a lawmaker, the number one job is to keep our community safe, and specifically our kids, which is why I focused really exclusively, primarily on kids' online safety. And as much as we can do here as the fourth largest economy to really drive that policy change in the ways that we can, that doesn't bump up against Section 230 or, other constitutional issues, we are going to do that. We have a privacy committee. We have a very, talented, staff that work there that are experts. We have ongoing relationships with opposition and supporters. And so as much as we can continue to push that, we are going to here in California. And our hope is that other states will follow suit. And frankly, that the federal government will follow suit, especially because going back to what I said initially, this, I think, is one of the only areas where we actually have, in certain contexts, real true bipartisan support on some of this stuff in a country that is very polarized right now on every other political issue. And so the more that we can come together, and again, coming together from my perspective and my experience as parents, as Democrat and Republican parents trying to solve some of these challenges, it's incumbent upon us as lawmakers to do that. So my hope is that we continue to push the envelope here in California, and other states can follow suit and our federal government can follow suit.
Great. Well, I think that's a great place to leave it. We're out of time. Thank you all so much again. It's been just fascinating to chat with you all. And for everyone in the audience, thank you for coming. Center on Technology Policy, we put together events like this frequently, so keep an eye out for other similar events. And thanks.